from Conservation Law Foundation is here to talk to us about the municipal harbor plan, and he'll give us an update and take some questions.
Here again, although I question your judgment and ask me back, but here we are. I wanted to bring people up to date with where the litigation is over the downtown municipal harbor plan, and I thought to do so because there are a lot of new faces here. Actually, since the last time I was here, I wanted to go over just some of the background of the law that we're trying to protect through this litigation. And that's Chapter 91, the Public Waterfront Act. And I just wanted to, it's one of those laws that's incredibly simple. It's like 3 or 4 sections. The critical section, Section 18, which says that no structures or fill for non-water dependent uses of tidelands. That's anything that isn't by its nature necessary to be on the water, like a marina or a boatyard or something that sort of by definition, functional definition, has to be on the water. No structures or fill for non-water dependent uses of tidelands, none, may be licensed unless a written determination by the department, that's DEP, is made following a public hearing that said structures or fill shall serve first a proper public purpose. So that every non-water dependent project has to serve a proper public purpose, and that said purpose shall provide a greater public benefit than public detriment to the rights of the public in said lands. And as we've talked before, most of you know that tidelands, people who own tidelands, own them with a lot of strings attached, as the Supreme Court has said. It's not like regular property off the waterfront where you get the whole fee simple to a piece of land. All tidelands have strings attached to them. The question is, okay, how do you determine whether or not something is a proper public purpose or whether the public benefits exceed the public detriments? It's one thing to put out a standard like that, it's another to actually implement it. And the legislature gave DEP the authority to develop regulations that would flesh that out and come up with a set of fair, equitable, transparent rules that would apply to these sorts of developments around the Commonwealth. And DEP did that in its first set of regulations was done in 1986. There's a lot of kerfuffle about it. Boston was raising a lot of that kerfuffle at the time. And Boston's issue was that they felt the regulations didn't give the municipality enough flexibility. And the reason they didn't give enough flexibility is there are 3 or 4 provisions that talk about what uses and what dimensional limits have to apply to any non-water dependent development on tidelands. And they're very specific, that the public has to have open access to at least 50% of the site. And the height has to step back from the waterfront, starting, again, as you visualize sort of the colonial history of Boston and the warehouses and all the things that people treasure about the city. The warehouses step back, and 55 feet within 100 feet was the number that was pulled out of the hat, as it were, but it was an elaborate public process that came up with that number. And then it goes back as you go farther from the waterfront inland to higher depths. The regulations said if you propose a development, it's not those who know zoning, it's not as of right you could build something. But the presumption is if you followed the DEP regulations and propose a development that complies with them, your development, by definition, practically serves a proper public purpose, and by definition, the public benefits are greater than the public detriments. That puts some municipalities like Boston in a straitjacket, who said, I think quite understandably, why can't we get more flexibility? Why can't we accomplish those same purposes with a more flexible approach? And that's where the municipal harbor planning process came in. And the purpose of the municipal harbor planning process under the regulations is to substitute a set of tailored regulations for an area in a municipality on the waterfront that are different from the regulations that DEP developed, but accomplish the same purposes. And so the regulations provide that these municipal harbor plans have to at least be as good for the public as the DEP regulations, if not better. So it's a pretty high bar. The municipal harbor planning process is run out of the Executive Office of Energy and Environmental Affairs, which, for those who don't know, is a political appointment operation. This isn't a regulatory group. This is a cabinet officer and people she or he brings into the executive office. The legislature gave the authority to make these public purpose determinations to DEP, which is a regulator. We were actually pretty concerned. I was amazed that I was actually able to find this. I've been saving it since we first wrote it in 1989, when these regulations were proposed. And one of the measures that we particularly pointed to, although we did support it, was this municipal harbor planning process. And in the definition section, we commented that these plans will have a major impact on coastal development and may well be highly controversial. That's a little oversight, right? They pose the risk, unless carefully scrutinized by the public, of circumventing the purposes of Chapter 91. And because once these municipal harbor plans are approved by the secretary, not the department, approved by the secretary, they are binding on the department in any future licensing that takes place within that municipal harbor planning area. So DEP loses the discretion it otherwise would have under Chapter 91 to do its job as the regulator and make sure that everything is fair and equitable. The political appointee makes the decision, DEP is bound by it. Our efforts to try to make the MHP recommendations discretionary as opposed to mandatory on DEP were not successful. Anyway, fast forward quite a bit. The process actually unfolded much more smoothly than a bunch of cynical lawyers like us thought it was going to unfold. And there have been a number of municipal harbor plans in Boston and other places that have not been consistent with the letter of the regulations, but they've honored the spirit of the regulations. So, to give you some examples, in the original South Boston Waterfront Municipal Harbor Plan, a proposal was put from the city to the Secretary of Environmental Affairs that looked at what kind of development would be maximally allowed under the DEP regulations. What's the total mass you could build under DEP's regulations? And what's the total height that you could achieve in these different sites? And how much open space would DEP's regulations require? And then they said, what we're going to do is move that around. So we want the flexibility to make some buildings higher, some buildings lower. We're still going to step back from the waterfront. The total mass of buildings that will be built in this area will be less, actually, than the total mass of the buildings that would be authorized anyway in the DEP's regulations. So it actually produced less mass. And the open space that was being proposed, instead of being 50% on each lot, they pumped it. So they came up with big usable public open spaces that were actually greater than 50% in aggregate. So they were honoring the spirit of the regulations. And that went on for quite a while, until actually the current administration. I don't know if the governor really has studied Chapter 91 very much or not, but the people in the Executive Office of Environmental Affairs have. And they've taken, from our perspective, a fairly radical new approach. And that's what's got us into court. It involves three issues, really. What are the heights that are going to be allowed, and how close are those taller buildings going to be allowed to the waterfront? How much open space is going to be required within the area that's being covered by the municipal harbor plan? And then, can you just buy your way, basically, out of DEP's regulations by coming up with a chunk of money that's kind of arbitrarily set? There's really no formula for it, for what the public detriments were that your building is going to present as a developer, so that you could use that money theoretically to go buy public benefits somewhere else. These were all big changes. We started off with a fight over the 150 Seaport project, because again, it was a big building being built right on the water with 70 or 30% open space instead of 50% minimum. There were all kinds of things wrong with it, and we were going to, I think we picked sort of our fight starting there, and the developer, either because he wanted to get it up or because we had a strong case or both, we settled it, and we actually produced a significant amount of money. It was still basically the same building. That wasn't negotiable, but the amount of money that the Secretary of Environmental Affairs had accepted for compensatory offsetting public benefits was silly. And we extracted, for the benefit of the city, a substantial amount of money that will be used for different projects that we specified in South Boston mostly. That brings us to the downtown municipal harbor plan, which is the one that was approved last year. I guess I sort of lose track of time, but last year, and it had two big adjustments. One, it was authorizing a building up to 600 feet at the harbor tower, at the harbor garage site. And for those of you who don't know this, can't scale this up, International Place 2 is 600 feet. So International Place 1 is like 585 or something. So these are big buildings. Harbor towers, which were actually constructed under the urban renewal plan in the 60s, before any of these regulations were even in place, are about 400 feet. So this is a building that is 2/3 bigger than harbor towers and as big as all the buildings on the other side. Height has always been a big issue in the municipal harbor plan process. I'm going to read two quotes. One is from the early 1990s when Sue Tierney was the Secretary of Environmental Affairs, and she was talking about the original harbor plan for Boston. And she says, in her approval, it's a widely accepted proposition that successive buildings should step down to a considerable degree. So, starting in 1990, this principle was, this is what the public wants as a look. It's not the only look the public could have chosen, but that's what the regulations required. And this is a little bit later one from the formerly called BRA. I guess this is 2010. The current zoning of the harbor garage is 155 feet. The Greenway guidelines, again, developed an extensive public process to try to do the right thing with this incredible asset that has been created out of a new highway, ironically, was protected. The Greenway guidelines recommend allowing a development that could be 200 feet tall. This represents a 30% increase in height. We are fully supportive of the redevelopment of this harbor garage site, as it is not living up to its full potential, and the guidelines are not anti-development. Rather, they recommend lower heights along the water's edge with taller heights along the city side of the Greenway. And this is our point. The $16 billion in public investment, and I think that doesn't even, the harbor cleanup was $6 billion, roughly. The Central Artery was, I think, who knows, 18 billion. I mean, the Green Line, the Silver Line, you start adding up the investments that we have all made in getting to the waterfront and making it an inviting place to be with your family. $16 billion is lowballing. BRA says the $16 billion in public investment makes the public a shareholder in the value that we have created for the private landowners along the Greenway. We don't want to devalue our asset by putting another barrier along the waterfront. Pretty good stuff coming out of the DRA. Of course, it was 2010. So now they're up to 600 feet phenotype. And then on the hook site is the other big adjustment that was being handled. The hook site is right next to the Northern Avenue Bridge, I think it's right, we got their name right. And it's sort of a derelict pier that the Hook Lobster property is on. They have a trailer there now, and it's a traditional old use. I mean, it'd be wonderful to have Hook sort of back in the way it was, but that is not going to happen under the harbor plan. Now, the harbor plan, they want to put a 300-foot building. They want to put it right out close to Fort Point Channel with about a 10 to 15-foot walkway around it. Anyway, so they're blowing through the open space, and in return, the developer has to pay, I think, $2.5 million, and I think $100,000 maybe to the Fort Point Channel Civic Society to program the channel, which is a good thing. On the Harbor Garage, developer, in order to get the 600-foot building, is obligated to put $10 million towards something. It says it should be going toward this, the New England Aquarium's Blue Way project, but you know that's a $150 million project. No one knows whether that's ever going to get built. So this chunk of money, instead of actually benefiting that particular property for the public's benefit, it's going into some fund, and we all know where those funds end up. They don't end up getting spent very often. And I think that the thing that was particularly, so two things were bothered us with that. One, this is really the first time where the state has put a price tag on public benefits. You know, what's a 600-foot building worth on a site that by authorization could only have a 155-foot building on it? How much is that worth to the developer? I don't know. They don't know. They just pulled a number out of their hat. And there's no process, there's no formula, there's nothing. How much is the extra open space that was lost on the Hook site? What's that worth? Is it worth 2.5 million? Is it worth 1 million? Is it worth 40? I don't know. You know, there's no process. It's just like a number that gets pulled out. So our big concern is that this law is supposed to produce public benefits on the ground, on the waterfront for all of us, while allowing private development to go forward. You know, coming up with kind of a Chinese menu of how much these different things cost. Well, we'll trade you 10% open space for X million dollars. You know, just seems to us to be purely arbitrary and a bad precedent. The second thing is the height issue, and the height issue is a pretty big deal, at least for those of us who believe in the rule of law, because you know that 55 feet at the waterfront wasn't pulled from the hat. That came out of a 5 or 6 year intense public process. A lot of debate, a lot of arguing, and that's what the community said. We can live with that. But we don't want big buildings right on the water. The secretary, in his decision approving the downtown municipal harbor plan, said, and the regulations say if you're going to have a bigger height, it has to be relatively modest. Now, so you ask, okay, relatively modest to what? You know, the DEP regulations of 155 feet, the Greenway guidelines of 200 feet, harbor towers of 400 feet. Relatively modest to what? Well, the secretary decided that he was going to judge modesty by the Boston skyline as seen from East Boston. And so this building was not going to be bigger than any of the other buildings, and times had changed since those regulations were written, and it was time for us to sort of move on and embrace big buildings. well, I think a lot of people disagree with them. I think most urban planners actually disagree with that philosophy in terms of waterfront development. But the additional problem, the fact that he did this, is that under these municipal harbor plan regulations, no one can challenge his decision. He's issuing essentially new rules that substitute for those old rules. Under the old rules, if a decision was made, the DEP rules, the legislature said, those decisions are appealable in court. You can hold the state accountable for the decisions it makes on public benefits and those licenses. The secretary's decision, where he has just adjusted everything in an arbitrary manner, they don't treat it as a regulation. They don't even think of it as a regulation, even though it clearly is. I'm just a lawyer. I'll slip into advocacy occasionally here, but it's clearly a regulation regulating future conduct of whoever's going to be developing on those sites. The secretary followed none of the state's rulemaking procedures, which again are there to protect the public against arbitrary action by state agencies. DEP was the agency that was given the authority by the legislature exclusively to decide what the public purpose is, what the balance should be, which they did in their regulations. Under these municipal harbor plan regulations, DEP has deferred that really critical decision to a political appointee, which was not, from our perspective, clearly not part of the legislative intent. As I said, we went along with this for a while because it looked like everyone was sort of honoring the sort of unwritten rule that you would come out more or less the same or better than the regulations. But in his last two approvals, from our perspective, they've just thrown all that to the wind, and there's virtually no certainty anymore about what development rules apply or don't apply along the waterfront. And so that's why I was going to court. The Harbor Towers, a number of residents in Harbor Towers, I don't know if there are any residents here, but yeah, a number of residents in Harbor Towers filed a similar lawsuit. They were raising the same issues as we raised, and they also raised a number of specific issues associated with commitments that I think they properly felt were included in the urban renewal package that produced Harbor Towers in the beginning. There were a number of stipulations that the municipal harbor plan abandons. So that's in Superior Court right now. We are, the basis of our claim is, number one, DEP has no authority to delegate that responsibility to the Executive Office of Energy and Environmental Affairs. Number two, even if it does, the Secretary's action is rulemaking, and at least he has to follow the rulemaking procedures, and he has to give people an opportunity to challenge rules that they don't think were properly made. And then we have a third claim about, we consider this environmental damage to the public. This loss of open space, this massing of buildings on the waterfront, from our perspective, is being taken from the public. So this is a form of environmental damage. It's in Superior Court in front of Judge Davis. I don't know how any of you are lawyers that work with the Superior Court. I don't work with it much, but it is challenging to get things through the Superior Court. But we do have a hearing date on the motions to dismiss that the state has filed on May 2nd. I think I'll point out that the Attorney General, who would normally, and in the 150C4 case, actually did represent the state in that case. In this case, the Attorney General declined to represent the Secretary of Environmental Affairs and DEP. They don't give their reasons, but I think they're troubled by what's happened to the process. And we'll see where it goes. The only uncertainty that I think exists right now is all the justices on the Supreme Judicial Court who have been very strong on protecting these public trust rights are new. There's not a single justice who's decided a Chapter 91 case before. So even though there's this incredibly strong precedent from earlier courts, we don't know what they're going to do.
We
Good.
should take some questions.
Okay.
It's like 5 of them.
Okay, we give two more, just
sure.
quick things before the questions. We've got a People's Guide to the Public Waterfront Act. We tried to put it in everyday language. I have some copies of it here. It's online. We also have an online publication called Climate Change and the Massachusetts Public Waterfront Act, where we're thinking about how the regulations that DEP has have to change now that we know that sea levels are going to rise, now that we know that storm activity is going to increase. How does DEP use its Chapter 91 authority to make sure development is climate resilient, or at least not making the problem worse? So those are all available, and I'm happy to make them available to you.
I understand that you won the case against Exxon, is that correct?
We won the first,
Go-around?
we're in the early go-arounds.
Thank you for that.
Yeah,
Thank
you're
you
welcome.
for that. That's
You're welcome.
an
It
important
was,
case.
It's daunting. Through a lot of lawyers.
We got a couple of questions.
Yeah.
We don't have a lot of time.
There are height restrictions in the north end that provide that no building can be built higher than the existing
55 feet.
55 feet. Does the,
That's under city zoning.
Yes.
it was a special zone.
Good, that's
zone,
great.
And I'm wondering whether that's at risk along with, because I gather the harbor towers and Hook are not in the north end.
No.
So are those at risk too, based on?
Well, there's some of the north end is in public tidelands. I mean, there's a map on DEP, you can sort of see where the line goes. It doesn't come much across Atlantic Avenue, if at all, I don't think. It sort of cruises along the east side of Atlantic Avenue. So those would be technically at risk. And you can get variances from zoning codes. So, you know, these are things you just have to be vigilant and in people's face about, because there's nothing development friendly about a 55-foot limit in Boston. So it's not constitutionally protected. Yeah.
Hi, Dave Kubiak, Cleveland Place. Thank you for mentioning that the Secretary of Environmental Affairs office is a political office, and I would say that it has become much more political over the last 20 years, especially over the last few years. We used to be able to count on the Secretary's office and the MEPA office to protect us, and that protection was realized by us in 1998 with the Battery Wharf project, and in 2006 or so with 585 Commercial Street. But I don't believe those protections still exist. I fear that they no longer exist. I have a couple of questions for you. One is, even if you lose the lawsuit against the Secretary's decision, can you still sue DEP when they issue a Chapter 91 license that you believe, even though it's consistent with the MHP, it violates the regulations and the law? And the other question is, does the MHP for the downtown waterfront address climate change impacts? Does it include mitigation requirements to mitigate those impacts?
Let me reverse the order. It does a little bit on climate change. We don't think the state's doing nearly enough. It's just not. But it does, it allows the existing buildings between the Marriott and the Hook site to go up, I think, 30 feet maximum in order to move their electrical and other kinds of vulnerable facilities up onto the top floor. So it does that. It deals with it to some degree by saying you can go up a little higher if you're going to do that. But that's basically.
But those protect buildings,
It's just to
individual
protect buildings.
buildings. They don't protect areas.
Read our report. I mean, the biggest area that's at risk are the public spaces. You know, the people who own these buildings are going to protect their buildings for sure, to the extent they can. But that green space next to them or the park, you know, we'll get to it. So it's not. So that's it on climate change. What was your first question?
Would you still be able to sue?
Challenge DEP. It would be difficult unless the license application varied pretty significantly from what DEP, what the Secretary approved. So there's some you know, something, it's, that, I mean, part of our problem is that we can't challenge these new rules in the DEP proceeding. The state now seems to be taking a position that we can challenge the MHP provisions substantively after DEP issues a license, which is nutty, but I mean, I guess if they, at least they create, they say that avenue's there. I can't imagine a developer, you know, going to all this risk with the notion that the underlying zoning plan or MHP could get pulled out from underneath them 2 or 3 years down the line after the license is already issued. So it's not set up in a way that really allows anyone to challenge the decision maker on some of these fundamental issues.
Thank you very much.
You're welcome.